Hello, I'm Eric Singleton with Kenshin Funeral Home, General Manager, Funeral Director, and Bomber here. And Kenshin Funeral Home has been around since 1938. My grandparents started the funeral home, and our first location was on Delord Street. I've been working here at the funeral home for over 30 years, and I want to make the funeral home a little more than just a funeral home, just a place you think of when you need us in a time of death. We're trying to make an effort to provide information to you that you could use whether there's a funeral or whether there's not. So we'll be doing a series of discussions, and today our first discussion will be about wills and successions. And with me, I'll let her introduce herself.
I'm Lucretia Pecantte, and I'm a practicing attorney. I've been doing this since 1995. My office is located in Liberia, but I'm all over. And I think this is a wonderful idea that you decide to do, because people need lawyers every part of their life.
For every day.
But dealing with this, when you ask me, I just think it's such a wonderful idea to give people the information that they need and just not call on Kenshin, like you say, in the time of death. I think that we owe a duty to the community to make sure that they are informed.
And that's what we hope to do.
Yeah, that's what we hope to do.
And so our hope is to give you information that you need, that you can use while you're healthy and while nothing's wrong, so that when you get sick or something happens to you, God forbid, your family is not at a loss for what it is you want to do. So today we're going to start, like I said, talking about wills. And we're talking about the different kinds of wills that there are, and which will might be better for you.
Well, in the state of Louisiana, there's 3 types of wills. First, there's what's called the holographic will. You don't need to go to an attorney. You don't need to go to a notary, but you have to make sure you have these 3 things: date, signed by you, and your handwriting. That's important, because if you miss one of those things,
It's done.
yeah, the will can be contested. Yeah.
And contested means?
Like someone can come in and say, oh, you didn't follow the proper procedure, or you didn't have the right elements to fit this will.
Thereby rendering it
Invalid. Right.
Meaning that you won't be able to enact it.
Exactly.
Meaning that your wishes won't be carried out.
See, he should have been in lawyer. Yeah. But anywho, yeah, well, remember, it's those 3 things, and it's called an holographic will. 3 things. You can write it on toilet paper, but it better have these 3 things. It has to have your name, your handwriting, and the date. You have to sign it. So if you sit down tonight and you feel like you're about to die,
Oh, you're not feeling like
oh, you're not feeling like you're about to
There's
die.
how to do it.
Yeah. So you sit down, paper, it doesn't matter. Date, like today, May 1st, in my handwriting, Lucretia's handwriting, and I have to sign it.
But you don't have to have a witness?
Nope, no witness.
Okay.
No witness, no attorney, no notary. Simple. It's called the holographic. The second one is called the statutory, and that's when you get an attorney involved, or you get a notary involved, because there's certain things that I got to make sure that's done.
Let me ask you this. I'm sorry. So does it matter how much stuff you have?
Nothing.
So you could be a millionaire and still do a holographic.
Yeah, you could say, I'm going to leave it all to Lucretia.
There you go.
Except, and we'll get into that, except if you have children under a certain age, before it was 21, I believe it's 25 now, that's infirm, or they're mentally or physically challenged. So therefore, you have to leave them 1/4 of the disposable portion.
And disposable.
Meaning, like if I take everything and I said, okay, I got to do 1/4. Like if I have a cake or a pie, I can leave 3/4 to whoever I want. But if I have that certain person that falls into that certain category, I got to leave them 1/4.
Okay. So 1/4 doesn't have to be cash. It could be property.
Or whatever, just so long as leaves 1/4 of those. So let's say I'm not good at math. So say you get $1,000. What's the flip of $1,000?
I got $100.
$100. So that's $25. So I got to leave him $25. That's the law. So, but in a statutory will, you go to a notary or you go to an attorney, and it's certain things that I have to look at. They have to have an attestation clause. They have to sign the bottom of it, and we can do whatever you want.
An attestation clause.
Meaning I appear before a notary, and these two witnesses, they saw me actually sign the document, and that is, which makes it valid. But your notary or your attorney will take care of that. You don't have to worry about that. Okay. And then the last one is the mystic will, where everybody is surprised. You know, it's really like in the movies, you know, you write your little will, and you know that little red wax, and you seal it up with the wax, and you put the little seal on top of it, and then you call everybody in, and
The seal is broken.
the seal is broken, and everybody's surprised. And everybody is surprised.
Okay.
So that's the three types of wills that we have here. Now, there are special provisions for the deaf and those that can't see. But those are a little bit more complicated, and I would tell you definitely go see an attorney for that.
Okay.
Yeah.
So the last two wills that you talked about would be if you, what is the advantage of doing those as opposed to
The first one?
Right.
The first one's free.
But yeah, that's what I'm saying. Why would I do the free?
Well, do the free one, but you better make sure date.
But then why would I want to go to an attorney or a notary?
Because some people are scared. Some people don't think that that's going to hold up.
Okay.
You know, or you might get older folks be like, no, I'm not taking no chances.
All right. And so if somebody decided to contest or challenge or say you didn't do it, then if you've done it with a notary or an attorney, then there's less challenge. There's less chance of a successful challenge.
No, because if you follow the three steps that I told you, nobody can challenge it.
Okay.
Because our law provides that you can do an holographic will. And that's perfectly legal. You just have to have those three things that we talked about. And you know, a lot of people get confused, and I don't want to go off topic, but between a will, a living will, and a power of attorney. Power of attorney. Let's talk about a power of attorney. Some people, a power of attorney is like you giving someone to step in your shoes to take care of your business, whether that's banking, insurance, paying the bills. Like if I just can't get out of the house, or I'm close to dementia, but I haven't been diagnosed, and I'm kind of forgetting things, and my son might say, well, give me your power of attorney, but you better be careful who you give your power of attorney to, because that person has access to do everything that you would normally do.
Such as pay your bills, access your account, and have control of your money and your assets.
Yeah.
House, your car.
Everything.
They can, with the power of attorney, they can physically transfer
In your name.
and transfer all your assets into their name.
Yes. So that's kind of a tricky thing, but a lot of people need it because they can't get out, or they just, for some reason, can't do the things that they used to do.
And that becomes important if you can't get out or you become incapable of speaking or something like that, because then that person acts on your behalf.
That's right.
Meaning that if, say it's your mom and your dad, and one is passed and the other's still living, and your dad passed, your mom's still living, and he was the beneficiary of her policy. So now, if something happens to her since he has passed, there's a whole process you now have to go through now to claim the proceeds of
That's
the
right.
policy. So with a power of attorney, it allows you to go into the insurance
change
company
that.
and change that to someone else, so that there's less confusion and less work, legal work, and less expense on the back end trying to get possession.
And I got a good tidbit. Let me just interject right there. What happens as well when you're dealing with bank accounts, I always tell people do an OR, like Eric or Lucretia.
Not an and.
Not Eric and Lucretia. Because say if we were married and something happened to you and we had an and, the bank will not let me touch it because they don't know who put it there. They know, but it's and. It has to be both of us. But
Signing on.
yeah. So if it's or, I can go there. If something will happen to you, I could go there and do what I need to do. If I needed extra money for flowers or whatever,
Or just live it.
you'll just live it, right? It has to be a whole R instead of A and D. So that kind of got into my head. And now, another little tidbit, now some bank accounts or bank allow you to do POD, payment upon death. But check with your bank to see, because then you won't have to do, well, I don't know, you might need a succession, but that just kind of alleviates that part of it to take it out of there. Because in your will, you don't put insurance because there's already a named beneficiary. With retirement plans, you don't do that because there's already a named beneficiary. Now with the bank, you could put a POD, which is payment upon death. So a lot of people have been frowning about that because there's other heirs. But if your federal institution allows it, why not take advantage of that? Right. So you can have those funds there available for you.
And that takes us, the power of attorney it's a very powerful instrument that can be used, that really helps, because it also allows you, getting to funerals, it allows you an opportunity to plan a funeral for someone ahead of their passing. Once a person has passed, the power of attorney then becomes
null and void.
Null and void.
It's only good while the person's living.
And so if someone's getting ready to go to a nursing home and there's some assets you need to dispense of so that you don't lose everything, especially if there's an insurance policy, you can then take some of the money from the account and use it to put a pre-plan service together and pay for it, and that eliminates some of the penalty that you'll encounter from the feds in terms of the Social Security benefits.
Right.
So that becomes important.
And then another thing, if your loved one have to go into the nursing home, I just never understood that. It's like you got to see 5 years into the future, or their benefits are being taken away. So, but how am I know I'm going to get my nursing facility 5 years? So I think we all need to call our legislature to have that part of the law changed. Yeah, because that's kind of crazy that I have to foresee things in the future, but who would have known that?
Yeah. Because I could get sick suddenly, and what happens is you have to spend it down to your destitute before you get any assistance from the state of Connecticut.
So let's talk about a living will. A living will is just, what they call that, do not resuscitate. That's every healthcare provider, if you go to ask, do you have a living will? And a living will is just a do not resuscitate.
It gives instructions. Your instructions for what happens to you if you get sick and are incapable of taking care of yourself or making any medical decision.
Yes.
And so it gives the hospital the direction as to what to do.
What you want them to do.
Right. So if I stop breathing, just leave me alone. That's what the living will tells. That's what it tells.
Resuscitate. You want to be resuscitated?
It depends on my age. If I'm not hungry, leave it alone.
But if I got little like me,
if I got tomorrow, you get resuscitated.
So those are the kind of things. But just remember, between what's a power of attorney, what's a will, and a living will. I know when I went to have my babies, that's the first thing they asked me, if I had a living will. And I think they do that all the time now.
Every time you go to the hospital, for whatever it is, they ask you if you have a living will.
Yeah, and if not, I think they provide you with one. Don't they?
I'm not sure. They probably is some kind of directive, but I'm not positive about that. Yeah. Hopefully I don't have to file out.
So now let's segue into what a succession is. A lot of, the first thing that I had to do with my father's stuff is unravel, because the community, we as a community think we own it, but do we legally own it? Everybody will say, oh, it's mine, but suppose you go to the bank and you need to do a mortgage against that property. Well, you won't be able to, because guess what? It's not legally yours. So what do I mean by that? Anytime a person dies, there have to be a succession. Now, what the will does, it tells you who you want to give your property to. Now, let's say you don't leave a will. Even if you leave a will, you just have to open up a succession, but all they're going to do is recognize your will. And your property will be distributed according to your will. So like I got 2 kids, I hope they're not listening. And if I say, oh, I'm going to leave everything to Lyndon, because sometimes, our children not so good to us, right? And they're over the age, so I don't have to leave that one forth. Well, my will says everything goes to Lyndon. Landon, I'm just joking, right? So then when they go to do my succession, they don't do it according to the laws of the state of Louisiana. I'm in control. This is what I want to have.
Because of the will.
Because of the will. Now, let's say you don't leave a will. Then that's when the laws of the state kick in. And this, in Louisiana, we're 2 types of property. We're separate property and we're community property. Community property is everything that is acquired during the marriage. From the time you say I do until death or divorce. Everything. Separate property is everything else, like inheritance or a donation just to you, or personal injury. Anytime you're in a car wreck, that's your separate property.
Come on.
Yeah. The only thing that is community, the medical, is the bill. That's it. But everything else, that lump sum settlement that you get, that's your separate property.
Okay.
So let's start with separate property. The order of distribution is as follows. If you do not leave a will, the first people to inherit are your children. That's inside.
If you're married.
Wait, I'm just talking separate property. And
Okay, second property. All right.
So if you have separate property, the first people to inherit are your children. That's inside, outside, upside down, children.
Okay.
Any child. But just let's say you don't have any children. The next class is your brothers and your sisters and your parents. Your brothers own what we call naked owners. They'll own it. But your parents will be granted the use of property, which means use. They get to use it. So let's say you just didn't have either the first 2 class. Then your surviving spouse will take your separate property. Now, let's say you didn't have no spouse. Now, here's the hodgepodge. Cousins, uncles, aunts, everybody else. And let's just say you didn't have nobody else, then the state of Louisiana will take your property. Then that's separate.
Okay, but let's go back to the children.
Mm-hmm.
So you said inside children.
Outside to the upside down to the...
And children, you say your children. That's not your children.
Yeah.
Then you shouldn't say that's your child and it's not your child.
If it's
Because
not
you get one person, how does it go? If you get one person to be Lord out of the city that you claim this child is,
That's an acknowledgement. That's an informal acknowledgement.
and so that child, even if it's not yours, becomes yours.
And that's why I think a lot of people run into problems. I'm sure you face that. But when they come in and they say, we want to put this person's name on the obituary,
Right.
and they name that person as a child, that's an act of an informal acknowledgement. And that person can take that and say, look, Judge, I want to acknowledge because I have 1 year from the date of the death of the decedent, which is the dead person, to prove my paternity. Mm-hmm. So therefore, that obituary can be used as an informal acknowledgement.
So that's why.
Yeah, don't be this out there. Don't be listening to all of them people, because that can cause a problem, and it might cause a problem for y'all as well.
It does, because if you, depending on the kind of service that you choose to do it, in cremation in most cases, you have to have 51% of the children to sign off if there's no wife. 51% of the children to sign off to allow the cremation to take place. So if there really is 3 of you who are blood, if you will, children, and there's this one person who he raised as his own, or y'all called brother, whatever, now that adds to your count. So instead of needing 2 people, or 3 people or 4, you need 4 of the 5.
Wow. So that you should be very careful in that. So the moral of that story, just make sure that you are who you say you are. If I'm a child, I got to make sure that I am a child of the person.
No, I have to make sure.
Yeah, but you know what I mean.
Yeah.
You know what I mean.
Yeah.
Okay, so we're going to pick up where we left off. So we talked about separate property. So let's talk about community property. And the best way I explain this for when anybody comes into a consultation is, think of a pie. To cut the pie in half, one half for the mom and one half for the dad. So it depends on who dies. Their children will take the dad or the mom's half. So let's say the dad dies, community property.
And no will.
And no will. So the law says my one half will go to my children.
Because I didn't write a will that says I want my half.
To go to my wife. Exactly. So therefore, that one half will be divided equally amongst my children. So now my children become a co-heir with my spouse. So my children would own the naked ownership, meaning, let's say this table. But you, as my husband, would get to use the table. Because you own half of the table as well. So the court at that point recognized your ownership, but also recognize your use or your right to use our table, our beautiful table. So a lot of people get confused about if I'm going to have a will or I'm not going to have a will. If you want to be in control, do a will.
Sounds like you really need to do a will, because otherwise you can wind up in a situation where your children, even though their mother has use of the property, they may try to force her into selling or give them their half or that kind of thing.
Well, not necessarily, because she's already owning her one half.
Right.
She,
But can they force her to sell?
well, eventually, yeah, because the law says I don't have to be co-owners with anybody. So therefore, I can force a partition. Partition?
Yeah. That's because it had to do with courtesy.
Of co-owned property.
Yeah, but it wasn't from my wife.
Let's keep
For my grandparents, for my grandparents, wait, that's straight.
So you force a partition because you don't have to be co-owners. So if you want to protect your spouse, then yes, you're going to need a will. And I'm sure your spouse will know what to do to give to your children or not. But I've seen a lot of situations where there's children and there's no will, and they're like, I want my share, I want my share. And what do you do with your mom? That's your mom or that's your dad. But some people,
Okay.
they don't care. We see a quarter with my nickel.
My nigga, that's it.
Yeah, so that's how that goes. So successions are really easy. If you want to be in control of your property, do a will. And I think that's so important for people to understand. That gives you that bit of control in saying who I want to get what. And if you in a will, you can say, I want my granddaughter to have my jewelry, or I want my grandson to have my car. But if you don't leave a will, that's not going to happen.
So the other thing, by doing a will and dividing up the property after that partition, you don't have to fight. Look, when you die and there's no will and there's no clear heirship, then if it's 6 brothers and sisters, then all 6 brothers and sisters are owners, co-owners of that property. If one of my brothers dies or one of my sisters dies and they have 6 children, their 6 children come in on their 6th.
Yeah.
And it continues to get convoluted.
Yeah.
And so
Really messy.
right, what's happening in every city, major or minor in the country, is that we have, and all came out with Katrina in New Orleans, because there's no clear title and because people weren't paying taxes. Now the property is being adjudicated and given for the cost of taxes to whomever comes through and buys it. So we are losing property,
That's right.
to people, and so nobody benefits in the family who had the property.
That's right. That's right.
And the old people used to say, don't sell your property, it's that's all you got, or whatever it was they used to say. But in essence, if you don't have to sell. But if my brother is a millionaire and I'm just making it, then give it to my brother and let me have use for it. And that way, I always have a place to be.
You can always
and
have a
he has control of it, and it doesn't get taken for nothing. And then upon his death, he can give it to his children, or he can sell it at some point upon my death. He can sell it,
Right.
and then at least somebody's gotten something for it.
That's right.
And it just didn't get
Because that's I've seen a lot where people lose their property for not paying taxes.
And it could be couple $100.
That's right.
You know, and you lose your property for a couple $100.
And just let me throw that tidbit. If you don't pay your taxes for 3 consecutive, well, it'll go up for sheriff sale. So let's say we go buy property for sheriff sale. I have to take care of that property for 3 consecutive years. And then I'll file suit against the landowners. So I have, as a landowner, I have one more chance to get back my property. But a lot of times people lose their property to sheriff's sale, and which makes it bad because guess what? It's tied up because nobody did a succession or nobody left a will, and one person bears the burden of taking care of the taxes. And when that person dies in the family, guess what? No taxes are being paid. It goes up for sheriff's sale, and there goes the family property that your great-grandmother or great-grandfather has worked so hard to establish. So a lot of, and I think Katrina woke a lot of people up to that. So I tell people all the time, take care of your business while you can.
That's right.
Because when you dead, you don't know what's going to happen to it.
It's a shirt show.
But I'm so happy and excited to be here because this is something that is needed into the community. Oh, and one more thing, Eric. When you inherit property, Louisiana got rid of inheritance taxes. So there's no more inheritance taxes. Before, when you used to come in and you inherited property, they would make you pay taxes. Even though we would have to figure it out, that tells you how old of a lawyer I am. But now, I think in 1997, the legislature did away with inheritance taxes.
Does it only apply to property or does it apply to cash?
It look whatever you have, whatever you have. But now we don't have to pay inheritance taxes. So that's for the state. And I think you and I were concerned about federal gift tax. Well, if you got $13 million, you got to pay some gift tax. But if you don't worry about it. You okay. You okay.
We don't have $15 million. I was right now, they have $13.
So don't worry about people tell you about taxes. No, you don't have inheritance taxes. And you probably more than likely won't have to report it for federal taxes, gift tax. They call it gift tax. But unless you have that $13 million threshold. Yeah. And it's so important that we get involved in the legislative process because they make the laws. People always yell at us lawyers, but we don't make the laws. We just have to carry them out.
But that goes to why it's important that you vote. People say, "Oh, I'm not gonna vote. It doesn't matter." It matters because you have people who make the laws who change the $13 million threshold to $1,000 and not pay taxes. You know, so
You're paying tax.
yeah, so you have to pay attention and you have to participate in the process of voting.
And I think also you have to get through that will.
Yes,
If
that's
you don't-
really
Yeah, that's really important. If it's somebody in your family that you don't think needs to inherit, do a will. If you want to be in control of who you want to have what, do a will. And recognize when you do a will, you can't control it. And I'm going to tell you about that. There's this case called I think it's Montgomery, where this man tried to say, okay, I'm going to give you this house, but this house has to stay in the family. And he starts controlling things. So one of theirs says, this don't look right. So a suit was filed against the estate, and the court said, no, once you give it, you give it. You can't, they say, control from the grave. So you cannot control from the grave. You can't say, because we like to, like you said, we want this house to be the family house forever and ever, amen, and that this person can live there, that person. Once you give it in a will, you give it. You can't tell them what to do with it.
You can, but it won't cut.
So just make sure you have a will.
Okay.
And make sure don't come give the funeral home too much problems with all these extra people, because those extra people can cause problems.
For y'all. For y'all. So, but we try to be as informative as possible when people come through. We try to share with you as much information as we can to try to make this transition as easy as possible. It's not easy. Emotionally and physically, it takes a toll on you, but you don't need the additional stress trying to figure out what the next step is if you take the step when you don't need to. And I know a lot of people are scared to do wills. A lot of people are scared to do pre-planning and that kind of thing because they think they're called a death or whatever. But that has nothing to do with it. Just because you sit down and tell your family, your children what it is you want, or you write it down, doesn't mean it's going to happen tomorrow. It will happen eventually for all of us. But if you don't... Not no time soon, please. I got things I don't need to do that I want to do. But it allows you some level of control as to what happens while you know what's going on.
That's right.
So we want to thank, I want to thank Lucretia.
I want to thank you for having me because this is something that's really needed. And if anyone have any questions, I'm located at 124 West Washington Street, Suite B in Roy Berry, Louisiana. But if you could call at 337-374-1202, I was about to give my cell phone.
There you go.
And just mention Kenshin, and guess what? I'll do a free consultation.
Oh, that's good.
Oh, see that?
See, it's all right. It's all right. I'm sure. Well, thank you again. Thank you all for checking out our website. This can be on our website. So visit as often as you like. You can call me or you can call Lucretia and get some answers to some questions. So keep looking. We'll have some more sessions coming up soon. Thanks again for tuning in.